This Week in Law is up next. Today, we've got Jeff Roberts from GigaOM and Paid Content, and our intern, Franklin Graves from Belmont University School of Law, is joining us as well. And Evan is, of course, here with us, too. We're going to talk about Apple's Good Week in Court and Bad Week on the Web, Google's and Facebook's opt-out snafus, and lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise, Howell, and Evan Brown, episode 169, recorded July 6, 2012. Bong hits with the S.W.A.T team. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter the promo code TWiL. Hi, folks. It's Denise Howell here, and you've tuned in for This Week in Law, where we talk about everything related to technology law, how it affects your life. We try and help you understand it and help you maybe learn a few things that you didn't already know. We've got a great panel for that here today. We have one of my favorite legal writers out there covering the field of technology law, and that is Jeff Roberts from Paid Content and GigaOM. Welcome to the show, Jeff.
Good to be here. Thanks, Denise.
Wonderful to have you. If you're not already reading Jeff, you should, because he covers tons of the topics that we cover here on the show. He does them in great detail and in a very informed and balanced manner. So I really enjoy your writing, Jeff. I haven't asked you yet, are you a lawyer or just very well informed about the law?
I'm a recovering lawyer.
You're a recovering lawyer.
I used to practice law, but I enjoy journalism a lot more, so I made the switch.
Got it. Well, yes, we're all recovering lawyers in one way or another. Even here, Franklin Graves, our intern, not even yet a lawyer, but he's doing his best to recover from his first year of law school over at Belmont University in Nashville, Tennessee. Hello, Franklin.
Hi there. Thanks for having me on.
It's great to have you. It's so great to have you as an intern, and it's great to have you on the show. We've mentioned Franklin on the show a lot. He's been helping us out so much this summer. He is responsible for our finally getting our ball rolling on the MCLE process. I have here in my hot little hands our very first application to get one of the shows approved for MCLE credit in California on our end. And once we do that 4 times and then submit yet another form to become an approved provider in California and a slew of fees, then you folks who are California lawyers watching the show can go ahead and get MCLE credit for free without any extra application on your end. And some folks should give me a shout, or Franklin let me know if I've missed it somehow in our emails. There may be other states. It seems like there should be other states where being approved in California is good enough.
There are,
yeah.
There are definitely a lot of other states that accept the out-of-state credit.
Great.
Or there could be plenty of states that says if California is going to approve it, there's no way we're going to touch it then. So, but for what that's worth.
Exactly. So I'm kind of concerned on that front, but our goal is to get approved as many places as possible to make it as easy for any lawyers who are listening to get continuing legal education credit in their jurisdiction. So we're really excited about that. Franklin's been helping a lot with that. And speaking of, law versus journalism, Franklin has a great mix of both. If there's anybody doing independent journalism on our team right now, it's Franklin, who goes out and, is emailing people who our stories are about and trying to get more detail. And if he has a question, have them fill in some details, let them know we're going to be talking about it on the show. So that's great, Franklin. We appreciate it.
No problem. Thanks for having me.
And of course, Evan Brown is here from Chicago, Illinois, and Hinshaw and Culbertson. His wonderful blog, internetcases.com. Hello, Evan.
Well, hello. Hope you are having a good end of your Independence Day week. It's good to have this conversation. Looking forward to it. Franklin, nice to finally meet you, so to speak. So we should have a lot of fun today.
We should. I'm definitely looking forward to it. Let's talk about something I actually didn't put in the rundown, but I don't know how we talk about This Week in Law without mentioning at least that ACTA got shot down by, boom, you see got shot down. Not even in the U.S., not by any of us cowboys here. But, and I'm gesturing behind me for anybody on the audio. I have a little cowboy pistol and hat behind us because we've got some other stories dealing with sort of cowboy tactics by law enforcement. But at least in the EU, there were no cowboy tactics involved. It was a well-considered and drawn-out process to consider and think about whether they were going to go along with ACTA. And boom, it got rejected. So just wondering if any of you all, A, were surprised about this. It's kind of hard to be surprised about it at this juncture. And B, have any thoughts or reflections. Maybe we should, instead of having a moment of silence for ACTA, we could have some moment of raucous cowboy hell-raising, because I think a lot of people were happy to see it go by the wayside. Evan, any thoughts?
Well, I mean, we'd seen some rumblings that it was going to go this way over there in Europe, a lot of negative treatment by it. So I was just wondering if you say there was no cowboy tactics, because that's like such a U.S. and American kind of term. What do they call them over there? People who, herd cattle and stuff. So, yeah, no surprise here. I guess that's part of the fireworks we should have let off a couple of days ago.
Right. Jeff, I haven't seen any articles from you about this. Is it something that you just thought was inevitable?
Yeah, I think the writing's been on the wall for a while. My colleague in Europe has been covering it. I think the interesting thing, though, is it's coinciding with the Richard O'Dwyer case, where the U.S. is trying to extradite that student from Britain over here. So incidents like that, I think, really are well publicized in the UK and Europe, and have really rubbed a lot of the citizenry there the wrong way. So I think a lot of the public in Europe was primed already to be on the lookout for things like this. So I think, ACT has been doomed for some time, but recent events have just put more nails in its coffin. Right.
Richard O'Dwyer is the kid who he made an application or a service that helped you find streaming video on the web. Do I have that right?
Yeah, it indexed illegal streaming sites. And I mean, in that sense, he's no saint, but how would Americans feel if they decided to deport an American college kid who had file sharing in his dorm and send him over to Europe to be tried? I mean, that sort of gesture, I think, really rubs people the wrong way.
Right. And hasn't Jimmy Wales jumped in pretty heavily on his behalf, lobbying for this not to happen?
Yeah, and I think in the post-SOPA era, there's sort of a baked-in audience that you can sort of inflame in the push of a button. So whereas this stuff used to happen more at 20,000 feet with sort of, international trade treaties, it was all pretty obscure. Since SOPA, a lot of people are more attuned to it, and there's kind of a baked-in audience, some of whom I guess you could call rabble, but that doesn't mean they're wrong, who are a lot quicker to jump and scream and wave their arms around when stuff like this happens.
Franklin, any thoughts on ACTA going finally and quietly away?
Mine were just along the lines of what Jeff just said at the very end there. I think the social aspect online movement of SOPA and PIPA greatly influenced how ACTA gained momentum in that way as well.
All right, well, let's, since we've journeyed across the pond to Europe, let's stay over there for a bit to talk about a very interesting decision from a court there concerning the first sale doctrine. That basically means when you compare it to cases here in the United States, specifically out of the Ninth Circuit, that in Europe you can buy software that is not on a physical medium, not a disk. It was never in a box on a shelf. It was downloadable software. And under this decision, you have a right to resell it. That's something that is far more in question in the U.S. As the result of the Werner versus Autodesk case, which we talked about a long time ago. Evan, were you surprised that the European court went this way?
Well, I didn't have much of a sense of how the European court was likely to go. I don't have a great sensibility for what the climate is for there when it comes to the first sale doctrine. In general, I think this is a really tricky situation for copyright. It's one of the most difficult issues for copyright in the digital age, because what we're talking about here, the first sale doctrine, it's actually codified in the U.S. Copyright Act, simply stated, is that if you acquire a copy of a work that's protected by copyright, for example, you go to the bookstore and take a book, a paper book off of the shelf and pay for it and go home, you're free to do with that particular copy as you wish, in as much as, dispensing with that particular copy. You can't, of course, make other copies of it or make a derivative work or do anything that implicates the exclusive rights of the copyright holder under Section 106 of the Copyright Act. But you're free to sell that at the yard sale or on eBay or on Amazon or whatever. That makes good sense when it comes to physical media that is or at least traditionally, historically, has been difficult to copy. Books, for example. It wasn't until the last 10 years and the advent of cheaper, good printers that you can have at home or print-on-demand services, it's only been fairly recently where it's been economical for the average user to make a copy of a physical work. And we all know, it's such a cliche to talk about how easy it is to make copies of digital work. So the principle underlying the first sale doctrine, which allows you to do pretty much what you want with that physical copy, makes sense for those works that are difficult or historically have been difficult or expensive to make copies of. With digital works, it's much different, and even though the idea of the first sale doctrine has gone to attach to things like CDs, where if you buy a CD containing Microsoft Office on it, you can sell that, and you're not violating the copyright in that. It's much more difficult to figure out whether it makes sense to have that in place for digital works. And what we see in the EU decision here is a real extreme fidelity to the first sale doctrine, in as much as the holding is you download the copy of the work onto the local environment, thereby obtaining ownership of that copy. That's very different from ownership of the copyright in that. So what we have here, at least in the EU doctrine, is that by downloading it, you have attained ownership of that copy, forsaking any idea that it's just merely a license. And it extends the rights of the first sale doctrine into that. It doesn't make as much sense in my mind to extend the first sale doctrine when it's a digital copy like that, whereas it would make sense, or does make sense, for actual physical, tangible media containing the works. So I don't know really what to make of the first sale doctrine in the digital age, is the simple way of saying it in my mind.
Right. Well, in the Autodesk case, the Ninth Circuit tried to say, well, if someone has made it, they put it in their terms of service that you're not supposed to resell it, and then they've made it difficult for you to do it. They've locked it up with digital mechanisms of various lockdown functionality. Then that's going to make a court tend toward saying that a first sale is not appropriate. And here, Franklin has dropped a couple of links into our discussion points for today about the U.S. iBookstore terms of service from Apple and Google Play's terms of service, just as examples of the fact that when you move out of the world of software, you're not in any sort of different world as far as the EULA is concerned. Both of these examples purport to prevent you from being able to resell an iBook or resell a song that you've downloaded from Google Play. Franklin, it doesn't seem like the the EU court considered how this might impact things other than software. Do you think it did?
I think that's a very good point, in that if you looked at I couldn't read the German version of the iTunes Store agreement, obviously, but based on the U.S. agreements, it was clear that iTunes, it didn't say anything about the music side of it from what I could read, but in terms of the App Store and mainly the App Store and the Google Play Store, those were focused on not allowing the resale or distribution of those applications that users are purchasing through their stores. And I think going back to Redigi and the music front, is they're a little different in that the CEO is hesitant to even use the word copy. He likes to use the word move when he's talking about their company accessing users' computers to move the songs off their computers and install software that basically is spying on the computer to make sure they don't go back and add those songs again. And so I'm assuming that on the software side of it, it will be the same aspect in terms of either the software serial keys or the iTunes account or whatnot would not be able to access those same downloads. But with iTunes and Google, for instance, I think it becomes a problem when you have to have the cooperation of Apple, for instance, to open up a user's account with them to say they've sold these particular apps and they no longer are able to re-download them. Because with Apple and Amazon and a lot of them now, the newer thing is to be able to download as many times again as you need in the future when you buy them originally. So I think that's where I'm kind of confused in how it's all going to play out for the US and even in Europe now if this court holding is implemented out in the long run.
Jeff, do you have any thoughts on this difference between how things are going to work for software in the EU versus the US? And do you think that we're going to also see a move in the EU toward people wanting to resell things other than software that happen to be digital purchases of theirs?
No, I thought Evan made the point astutely that applying this for sale doctrine in the digital age is just going to result in confusion. The only thing I can add is it's interesting that the American case involving a book publisher is before the Supreme Court. The American Association of Libraries intervened yesterday, arguing that tightening the screws on the for sale doctrine to require products to actually be manufactured in the U.S. Suggests that copyright owners are getting more aggressive about it at a time when it seems increasingly harder to enforce given digital distribution. But I thought both Franklin and Evan sort of summed it up very well.
All right. Well, let's move on to some interesting developments from Google and Facebook in the last week or so. Both of them making missteps when it comes to making a new service or feature opt-in versus opt-out. Of course, folks have probably heard and rolled their eyes about the fact that Facebook changed or gave everybody a facebook.com email address and then changed everybody's default email address on their profile page to the Facebook one, prompting folks to have to go in and change that back if they don't want to be reached at facebook.com for their email. And of course, there was this snafu with the mobile device address book app that updated folks' emails to their facebook.com email address when that's probably, something they would never use. And there's lots of brouhaha about folks losing email, not knowing how to access their Facebook email. So once again, Facebook managed to ruffle a bunch of people's feathers by just sort of dumping all the users into a program without getting their consent first. And then Google essentially did the same thing with its new events feature. Maybe not as bad because email is one thing, and I don't know, calendaring though, people are pretty protective of what goes on their calendar, what is on their calendar. Google rolled out its new events feature and then accidentally started putting things on people's calendars that no one had approved being there. If you watched TWiT last week, there was the funny clip from Robert Scoble on the Gilmore Gang, basically just teeing off on them. But that wasn't the end of it. They also defaulted the notification settings for these new events to on. So even if you weren't finding a wave of new things on your Google Calendar, you were until you went and turned it off manually, getting a slew of emails about all the various events that you'd been invited to. So I bring this up because it seems like after all this time, companies would have learned this lesson, and this whole terms of service issue of what they can and cannot do keeps running into users' expectations of what they should and should not do. Jeff, do you have a take on this?
It's frustrating because in reporting on this stuff, I feel like I write the same story every week. Fill in the name, Google, Apple, Facebook violates your privacy. And then next week we'll hear about the lawsuits that grow out of this. and then it sort of goes into a black hole. And then we'll hear about a settlement in which some of the money will go to privacy groups who will use that money to go and sue these companies all over again. And it's tricky. I mean, I'm not entirely against the companies in that they're providing a lot of very valuable services for free, but there does seem to be a bit of an arrogance. But I think on the company's end, there's a frustration that most users have a very hard time understanding what's going on in the first place, don't have the technological literacy to keep up with what's going on. But what the long-term solution is, I just don't know, because at the same time, both Google and Facebook are under 20-year consent agreements with the FTC that's supposed to regulate exactly this. So I don't know if these sort of companies almost need kind of citizen oversight bodies that could perhaps translate what they do into plain English without handcuffing the companies. Because if we put too many restraints on the companies, they won't be able to innovate anymore. But it's frustrating. It feels like we're going in circles, doesn't it?
It does. And just, you know, the whole message of make things opt out as opposed to wait, do I have that backwards? Make things opt in. Folks need to affirmatively opt in and shouldn't be made to opt out of new features that, you know, affect important things in their life like email and calendar. I would think that, you know, especially with the FTC oversight, that would just be second nature at this point. This month, we just saw MySpace added to the slew of folks that are under 20-year scrutiny from the FTC. In MySpace's case, they had said one thing in their privacy policy, that they weren't going to share personally identifiable information with their advertisers. And then on the other hand, they were giving advertisers the actual user IDs that they could match up with anonymized information, if I understand that correctly. And so that was a no-no. And I would think, as Cash Hill pointed out on her blog, that this step from Facebook and possibly the one from Google too would run afoul of their agreements and understandings under the FTC's scrutiny as well. Franklin, one of our MCLE passphrases for this week is going to be opt-in in honor of all of this. What are your thoughts?
I don't really have much to add. I mean, obviously I wasn't affected like Will Wheaton on Google Plus in terms of getting all those invites from people I didn't know, but it does seem to be an issue. I know when I had my old Android phone, I kind of didn't like the fact that it would automatically add contacts from Facebook of people that I didn't really care to have on my phone. So going forward, I guess as Jeff was saying, we do seem to be running in circles, and you don't want to hinder the companies from doing great innovative ideas like this. But at the same time, there has to be some accountability for when huge problems like this arise.
Right. Evan, do you think that companies will begin to get this right, or are we just going to have to keep repeating the same story?
We'll just repeat the same story. I mean, to be honest, I feel a little bit guilty sitting here talking about this stuff. I mean, these really are first world problems, aren't they? I mean, 18,000 children die every day around the world of starvation. We're sitting here griping and moaning about stuff like this. So,
what emails we're getting and what's on our calendar.
Right. Jeff said it precisely when, you know, he feels like he's writing the same story over and over. You know, there's something like this happens. There's an apparent disregard for the terms of service and users' expectations. And if you go back and read the terms of service, it's probably actually allowed, you know, for this to be done. But in any event, I mean, we see the same pattern over and over. It's just like you're applying a template over the fact pattern. And Jeff talked about, you know, these things happen, and then there are some class action lawsuits that are filed a few days later. The only thing that I would add to the usual pattern is, and you know, there's even become a pattern of me making an observation of this pattern, is that I can't believe that Ed Markey and Al Franken haven't, you know, made a huge deal about this yet. Maybe they have. It's just that it's kind of faded into the white noise of you know, all the brouhahas that they make. So I'm starting to get a little bit cynical about it, and just recognizing that this is one of the consequences of dealing with companies like Facebook and Google, who are dealing with big data, and it's no small effort to launch new features when you've got almost 1 billion users in the case of Facebook. So as long as there's going to be some kind of public oversight of this, in as much as the users are going to complain about it. And I think the whole Will Wheaton and Google situation is kind of entertaining, because there were plenty of people who were griping about the fact that Google Plus events spam was occurring. But Will Wheaton, of course, a very visible character, was speaking out about it, and Google certainly turned lemons into lemonade with that, speaking directly to him. Oh, we'll fix the problem. Doesn't Google come out smelling like a rose, from having done the fix in this way? So this is just a part of it. We've got to get used to this pattern. It's just part of innovation and new releases. And let's worry about the big problems instead of getting too uptight about this kind of stuff.
Yes, my favorite thing about the whole Will Wheaton issue and his post about it was, of course, that Google responded, yes, that was good. But also it prompted me, rather than just reading his posts on Google Plus in my stream, I actually clicked over to his profile and realized that under employment, he works at your mom, and he attended Starfleet Academy, which, of course, we all know. Just love the guy. Let's see. Moving on from this, one thing I know that Google will, or as it rolls it out, I think to select few people, certainly must be making it as something that folks affirmatively opt into, is Google Now, which is, I think, in limited release on some Android devices if you're a super special journalist, reviewer type person. Cachefly has a really funny article about all the alarm that is coming out about Google Now. She calls it Google Now's terrifying, spine-tingling, bone-chilling insights into its users, and takes on a couple of folks, including John Dvorak, over calling this spooky and creepy, where, Cache pretty much concludes that all it's doing is being very convenient and helpful. That certainly there is a line between convenient and helpful that you cross over into spooky and creepy. But she doesn't think that line is crossed until she gives a number of examples that are quite good. If you wake up in the morning and you're told to skip breakfast because Google Now has checked with your Why Things scale and realized you're putting on some inadvisable pounds, or if at lunch Now advised you to start looking for a job because it checked in with your bosses now and saw he had scheduled some interviews with candidates to fill your position. Now might be tracking your driving speed using its GPS and notifying the authorities when you are 15 miles over the speed limit, and taking video so that the cops have evidence, to take you in. During dinner with your significant other, it could analyze your respective Facebook profiles and decide you're not compatible. And then if you ignore it in classic sort of Howell style from 2001, it could start spitefully sending your partner a sabotaging text message. When you arrive home alone and depressed, now it suggests some adult entertainment for you based on your past viewings. And then as you're falling asleep in your lonely, empty life, it starts playing Another Lonely Day by Ben Harper because it feels badly for you. So yes, all of those things would definitely qualify as creepy. And I think the takeaway from this is, against the backdrop of our prior discussion, is that as long as Google's pretty cognizant of where that line is and it very carefully gets people's consent to the kind of information that it's aggregating and the kind of information it's feeding back to them, then I think it's going to be okay with Google Now. Jeff, do I have that right, or do you have another take?
At a certain point, I don't know. Because that line of thinking is sort of like, why fight it? The younger people, their privacy standards are so different from ours. Let's just own it. Who cares anymore? Mm-hmm. But in reality, I suppose that's kind of how it is. I mean, I've complained about a lot of intrusive privacy things, but I use every one of them. So I suppose you're right. Google seems to have a knack too for pushing it right to the line, and then you get used to it. Then it pushes it further. And I'm still using Google. I don't know about you.
Yeah, very much so. Evan, what do you think? We think you're very quiet, is what I think.
Yeah, my bandwidth cut out there quite a bit, so I've been absent for about the last 45 seconds. Franklin, help me out, buddy.
Yeah, we're talking about the creepiness of Google Now and whether Google's going to walk into it with this, or whether you think that they can adequately get people's informed consent. It's almost like they're performing an operation here. They need to be very careful about how they roll this kind of thing out and what kind of consent they get. But if they walk that line right, I think they're going to be okay.
Well, isn't there? I mean, are we supposed to be surprised about any of Google doing any of this? Isn't this what the big privacy policy change at the beginning of March was all about, so that the services could be more integrated? And so Google is doing what it should do, doing what it must do to roll this out. And it's all just going to be a decision at the level of the user whether they want to buy into this. Google's doing everything that it could be doing or should be doing, and is responsibly expected to do. So I don't understand what a criticism of Google would look like in all of this. It's got to be at the individual decision of the user. The thing that would be nice is if this wasn't something that was done by a service, a party that had access to all this information. It seems like there would be a real space for the kind of granular personal assistance that Google Now could give you without it being aggregated in one place somewhere on the cloud. It'd be nice if it was much more distributed to do that, but Google has no economic interest in providing that kind of service, so it's doing everything it should be doing. So,
right. The thing that cracks me up about Cash's tongue-in-cheek examples of what would be creepy is that if you take each one of them individually and think about it, there probably already are apps out there that do this. These are actually features, coordinating with your scale to tell you if you're crossing a line and maybe should be cutting back at lunch. These are things that people actually want to have happen, even though they cross the creepy line, I guess, when you think about offering up that service against the backdrop. Franklin, what sort of world are we headed for here?
I'm sorry, I think it cut out the last. All I heard was what sort of world are we headed for here?
Yes, where I'm thinking that each and every one of Cashfly's tongue-in-cheek examples, if you took them and made an app out of them and put them in the App Store, they would do well, even though they crossed the creepy line for her when presented against the backdrop of all the information that Google has about you.
Yes, I definitely agree. There are already apps out there that will tell you your favorite sport team, what their latest scores are. I think that the difference is Apple has the power, and Google has the power of Google behind them. The Google Now is accessing a Google search is essentially what it's doing. And I actually tried experimenting on my iPhone, and I used Siri, and I noticed every single Siri inquiry that I did, besides a tongue-in-cheek kind of question to her, was based off of the Wolfram Alpha database system. And I'll be interested to see and myself classify the service Google Now as creepy once the reviews and people actually start using it outside of the bounds of what the little promotional video that Google has out there. Once people start using it outside of those boundaries of your favorite sport team or which friends are out there near you, which Facebook is already doing with the nearby feature. But I think that the Google Now feature, it seemed it had more power behind it because it was essentially doing a Google search for you. And that was the difference that I found in the other services that are already out there like that.
It's kind of inevitable, don't you think, Jeff? It's sort of like the search for the Higgs boson, which apparently was resolved favorably this week. The search for the truly intelligent personal assistant AI that's going to enhance your life and not be creepy continues. And I think, Google has that in its sights.
I suppose it's still creepy. Location creeps me out because I don't like the idea of being able to be found everywhere. I don't like walking around with the tracking chip in my pocket. So for me, that's a bit of a line, but it seems increasingly we just sort of accept that too. I don't know if you agree, but I don't. Also, I'm encountering parents who now have teenagers' cell phones, and they turn on their kids' cell phones to track them. Is that good parenting, or is that creepy?
Maybe it depends on the kid.
Yeah.
As a parent, I could see certain circumstances where that might be a good thing, and certainly I could see where it would be too intrusive. So we live in a complicated world. Especially, Evan, we live in a complicated world where we might be in a workplace environment where we share computer access, say at a school where there's a computer lab, and maybe the teachers duck in there to check email on a break, and they're cheek by jowl or mouse by keypad with each other, and they might jostle something such that the machine next to them comes to life. And lo and behold, their colleague, who's now departed for the coffee room, has left their open email account there ready to access. And lo and behold, the person looking sees their own name in some of the subject headers. What happens when all that happens?
Oh, somebody's got to get sued, it sounds like. So what you're teeing up is a decision that came down from an appellate court in New Jersey this past week, and I wrote a post about it on my blog at internetcases.com. Like you said, you gave an outline of the facts there. The guy came into the computer lab or the computer room at his school, set down his drink, and moved the mouse and disabled the screensaver on the machine next to him, and saw that his coworker hadn't logged out of her Yahoo email account there. And so he looked over and saw the court refers to it as the index of the inbox, the list of all the messages there, and he saw his name, and the guy was involved in a workplace kind of dispute. There was some kind of issue. People get uptight at work about issues like this. And so he, moved over and started clicking on the messages and looked and read he clicked on the messages where he was mentioned in the subject line and read them and printed them out and used them later at a meeting where they were discussing whatever it is that they were in a dispute over. So the teachers who were exchanging email that he clicked on and opened, he was, of course, not party to that email, but they sued him under New Jersey's equivalent of the Stored Communications Act, which prohibits one from accessing stored electronic communication in a way that either is, without authorization or exceeds authorized access. And it's the exceeds authorized access question that was interesting in this case here. Long story short, the court held that by doing what he did in these facts that we've set out here, he did not exceed his authorized access. So it's kind of an intriguing situation. So this went to a jury, and the jury found, and I don't know what the facts are. I'm not like Franklin. I didn't do some great journalism here and call up the lawyers who represented the parties on this, or even go try to do some research into the court file. But there were some facts in the record that proved that, at least to the jury's satisfaction, that his access, his going in and clicking on these email messages did not exceed the authorized access that he had by just going over onto this computer where the previous user had failed to log out. To me, it seems like reasonable minds could really differ on the outcome here, because I can't imagine a set of facts where a person just gets up and leaves and unintentionally logs out. Maybe that was one of the facts. Maybe she didn't intend to log out or something like that. But it's just really hard, and with our modern sensibilities of who can get into our email accounts, it's really hard to imagine that a person would allow, especially their workplace rival, to have access to this stuff. So an interesting conclusion, an interesting holding that, like I said, reasonable minds could certainly differ with, I believe.
Right. And it's certainly, it's not hard to imagine a situation, since they were already in a dispute, where he comes into court and tells the story of, whoops, my coffee cup touched the mouse and disturbed the screensaver. Or, he's watching for her to go use her email and then quickly leave the room, and he sneaks on in. Of course, juries are supposed to be able to suss out that kind of fable, if that's indeed what it was. But you just don't know. And we don't have a whole lot of appellate guidance on these points either, because the only issue that went up to the Court of Appeal is whether the case should have gotten tossed out on summary judgment. The Court of Appeal came back and said, no, it was appropriate for this to go to the jury. The jury came up with this concept of tacit authorization that, speaking of creepy, definitely creeps me out about this case. That, if you stay in... Fortunately, I don't know what kind of precedential value this decision will have or this outcome will have, because it's, again, just a trial court decision in a state court, and there's no really citable thing you could come back to here. But once something's on the books, people tend to come back and cite it, even if it's not very weighty or persuasive. But the jury found that by staying logged into her email, she had tacitly authorized people to access it. That seems to me quite a scary thing to have promulgating out there. What do you think, Jeff?
I'm not as familiar with the case, but I think you're onto something what you said just there. There's all these new frontiers, and at the first instant level, you're probably going to get some ugly results like the one you described. But it seems that, I don't know when that fact pattern is going to show up again, but it seems like it'll happen in other states and in higher courts. And I'm sure this will come up with a better solution than that.
Right. And of course, Evan, your pro tip, be sure and log out when you're on a shared computer, is pretty obvious. But it also, I think, happens all the time. Franklin, you must encounter this kind of thing in a law school environment where people are sharing machines.
That's actually really funny, because I was just sitting here thinking about the fact that when we're given those lovely 5-minute, 10-minute breaks in classes, everyone knows now after the first year to not leave your computer, because it wasn't uncommon to see other people walk over to your computer and change a funny status update for you, or swap out your profile picture. I mean, in my understanding, growing up, like the past few years through college and whatnot, if you left your Facebook account or even your email open on a public computer, or even your own laptop sitting there that you walk away from, it was bound to be messed with. It was just understood. That's why you needed to be careful. And there was this level of diligence that you had to follow and understand that would happen to you. So I think that is, it's not a good method at all to follow. And hopefully we'll learn that as law students over the next 2 years that we have left. So it'll be interesting to see if this comes back, whether this jury decision will hold and stick up in the future.
Denise, did you hear?
Go ahead.
Oh, go ahead. Yeah.
Well, I was going to say, IRC thinks this is pretty funny, as I do too. They're saying, you crazy kids. Practical
exactly
joking in the digital age.
Yeah. Did you hear Franklin say that he was on Facebook when he was in college? Isn't that amazing?
Oh, yeah. That just kind of went right by me, but yeah.
Right. Well, I mean,
I was holding out for that college email address to get an invite to join Facebook, so that's when I got to join.
Yeah. Well, where I see this being relevant in the future is not so much in the computer lab, but in the context of the mobile space.
Sure.
We carry around our devices with us, and if I can after I enter my 4-digit passcode to make this machine come alive here, a person can access my email account, my Twitter account, my calendar, everything else. So I'm always logged in. Essentially, the analogy maps across at that point there. So to me, it seems like the fact pattern that is likely to give rise to this legal question again is what happens when a device is left on the countertop or found on the street or whatever. Have you given tacit consent for whomever finds it to go and look through your stuff on there? So, and as I addressed in the blog post, it's certainly going to depend on the factual situation, whether or not the access was authorized, or whether doing that exceeds the authorization that the user of the device put into play here. So I was kind of being tongue-in-cheek when I said the obvious pro tip is to make sure you log out of the system. The general way of saying that is to make sure you put some kind of contours on what the on what the scope of authorization for others to access the device is, so that if there is a dispute over this, it's clear and can be easily proven that the defendant acted outside of whatever authorization he or she may have magically had when he or she went and did the evil deed giving rise to the litigation.
Right. And on the mobile side, too, I'm a big fan of the fact that Apple has this Find Your iPhone app. And I'm not sure if there's an equivalent in the Android ecosystem. But in addition to finding it if it's lost, as long as it's on, I think, you can wipe it remotely, which I've had to do a couple of times now with lost devices. And it's just, you sleep so much better at night knowing that even if someone has made off with your thing, they haven't made off with all your data. Any final thoughts on this, Jeff?
I think the more interesting, one thing that comes out of the mobile came to mind is police, when they apprehend suspects with cell phones. I think there's some cases out there where they're trying to figure out how deep can a cop dig into your cell phone when you're apprehended. Mm-hmm. Can they go into your contacts? Can they go into your email and so on? So while this is percolating on the civil side, a lot of that sounds to me a lot like going to someone else's diary in the old days before we had these devices. How do you like to be the girl or the guy in high school whose diary is read to the whole school? That sounds, some of these computer cases sound a bit like that. But on the criminal front, I think there's some more serious civil liberty questions there too.
Yeah, definitely. All right. Well, we're going to take a break here. We're here with Jeff Roberts from GigaOM and Paid Content, and Franklin Graves, our wonderful TWiL intern for the summer, who is just about to start his second year of law school at Belmont University in Nashville, Tennessee. And Evan Brown, of course, from Hinshaw and Culbertson and InternetCases.com. And we have a great sponsor for this show that actually addresses one of the problems that we were just discussing, who has access to what via email. Now, if someone is logged into your email without your consent, I don't think actually ShareFile is going to be able to prevent that for you. So you still have to be careful how you're managing your email account. But ShareFile definitely gives you a level of security and comfort that you wouldn't otherwise have, because if you are the sender, you can put very fine-grained controls over who sees what and what access they have to what you're sending them. Now, the reason that you're going to want to use ShareFile is because, of course, sending and receiving documents through email is a part of what we do each and every day for work and everything else in our lives. But sending large and important files as regular attachments can be risky and frustrating. Of course, you get bounces back when something's too big to go through. You're not sure who else could be accessing the files. If you use ShareFile by Citrix, it makes business communication easy and confidential as it could be anyway. With ShareFile, you can send files securely of almost any size. It's so easy to use. All you do is you select the document on your machine or the file that you want to send, and your recipient receives it directly as a link in their email message. And then you can track when they download it, and you can set access controls so you know it's secure. Plus, ShareFile has an amazing support team, and they will answer any question that you may have about getting set up and using the service. They're really dedicated and wonderful in that regard. Now, in my personal case, the thing that I find myself sharing a lot that won't go through email, most legal briefs, okay, that's just a largish size document. But as soon as you start attaching images to something or video to something, or if those legal documents start to get really, really big, like the attachments that you might have to a motion or a brief, then you're going to need another alternative. And rather than, phoning up a messenger and having something delivered, that's difficult to do if you're dealing with someone who might be across the country or across the world. What I do, and where I find this coming up over and over again, is with presentations, because they, first of all, have tons of photos in there to pretty them up, and video too to make them interesting. And as soon as you do that, you're just not able to send it as an attachment. So what are you going to do? Well, what I do is I use ShareFile, and it just solves the problem immediately. And even those very large files can get across to exactly who they need to get to in a speedy and secure way. So we have a great offer to get you started. You sign up today and you will get a 30-day free trial of this service, absolutely free. Kick the tires on it, send the most enormous things that you can imagine, and let us know how that goes for you. To do that, go to sharefile.com, you click on the radio microphone and enter the promo code TWiL. Remember, that's visit sharefile.com and type in the promo code TWiL, T-W-I-L. Thank you so much, ShareFile, for making large files easy for all of us to send. All right, let us go on with the show, as they say. We've got lots of interesting stuff we could go to next. I'm thinking we should talk about Apple's Good Week in Court. We have Judge Koh here in California seems to be the anti-Judge Posner. Where Judge Posner was cutting things off, Judge Koh is granting preliminary injunctions in Apple's favor regarding, first of all, the Samsung Galaxy 10.1 tablet, which may be kind of a moot issue, and we'll have Jeff explain why in a second. But also, Apple got a ban on the Galaxy Nexus phone, and folks are wondering if the Galaxy S3, the latest and greatest one, is going to be next in the sights and the next victim of this patent that Judge Koh seems to be finding is worthy of issuing a preliminary injunction. That's a pretty high hurdle. Jeff, you've been covering this pretty extensively. Where do things stand here?
You mean in particular with Judge Koh in the California cases?
Yes.
Yeah, I think it's useful to keep in mind these sort of tiffs are playing out not only across America, but in two different forms in America. They're happening at the International Trade Commission, which has the power to restrain imports, and also in the federal court system, and also in Europe. So it's at some point it can get hard to keep track of it all.
Right.
Let's turn first to the tablet. That was interesting because that was based on a design tablet, design patent, which are this sort of smaller species of patent that covers the way something looks. Judge Koh initially said, no, that's out because it's obvious. It went up to the federal circuit, who sent it back down and said, no, it's not obvious, try again. So she went, okay, I guess I'm going to have to issue an injunction. But at that point, it doesn't really matter because that edition of the tablet is technology moves so quickly. New iterations come every 6 months or something. So by the time Apple finally got the injunction, Samsung is on to a new model of that same tablet that doesn't resemble the iPad as much. So they're okay on that front. And on the phone, meanwhile, I hear they've got a workaround sort of locked and loaded that's set to come out any day now. So I'm not sure what to read into this in the bigger picture. I think the Posner stuff is more interesting because someone's sort of blowing the whistle and calling sanity on the whole process. But
that's right. So we've discussed what Judge Posner has done and the dismissal of the case that was pending in Illinois. And then I guess he came out this week and made some further explanatory comments to, was it Reuters, Jeff?
He spoke to Dan Levine at Reuters, his good legal reporter, and also he went on NPR of all things and talked with Nina Totenberg more about the state of the country and the Supreme Court. But it's interesting, just given his immense credibility, because when I was in law school, all liberals used to hate Posner because he was an insensitive, law and economics type. And now he's sort of, now the conservatives hate him because he's not respecting property rights. So I find him a particularly formidable figure to watch. And I like what he did with the Apple, Google, or the Motorola case. He sort of set out a roadmap for other courts, for Congress to hopefully fix the mess. And in the meantime, I think Judge Koh has got the federal circuit breathing down her neck, so she's doing what she can. So I'm not sure what's going to happen next, but you almost get the feeling this has got to come to a head sooner or later.
Right. Now, I'm going to toss this out here. We got a fairly detailed question from a viewer on Google+, Keith Acorn, who wanted to talk about the unified search patent, discussing what would be valid prior art for such a patent. He's interested in the relevance of Google's own desktop search program. He says, you may recall that this program searched not just by file names, but by the content of various file types on a user's computer and on the internet. There have been allusions to other prior art from before 2000, but this one struck me as particularly interesting. Thanks, says Keith. Well, thank you for asking the question, Keith. I'm going to toss this to Franklin, who took a look at this, and but my preliminary answer is prior art is kind of a crapshoot, and yes, that might well be relevant. What do you think, Franklin? Are you there, Franklin?
About the patent system, I'm actually going to take intellectual property in the fall, so I might not be the best person to ask about this. But I did notice that I found some links about the Google's desktop search indexing algorithm, and there were a couple of key differences. I'll post the links to the actual patent filings in the show notes. That way people with more insight into what they actually mean can look at them and hopefully find an answer. But the patents that were filed by Google just a couple months before Apple filed the ones for their search algorithms seem to be different in the way they analyze when they're searching the computer, because the Google desktop search program was actually discontinued by Apple. I think 2011 is what it said online. So I don't really think it's an issue that much anymore, other than Apple would own the patent for searching through the files. But the problem was whether or not it would be able to go and look into the actual files and search those as well. But like I said, I'll post the links to the actual patent filings, and you'll notice there in reading, there are a couple differences between the patent that Apple filed for their search capabilities and the ones that Google filed.
Okay, thanks for that info. Of course, prior art doesn't have to be used in litigation to invalidate a patent that way. It can be used, and many argue should be more aggressively used by the Patent Office itself in considering whether patents should be granted. You reported this week, Jeff, that the Patent Office is expanding beyond Washington, D.C. We're going to see one in, where is it, Dallas and in San Jose, and it was one other place?
Denver, I think, got one too, and Detroit as well got the first one.
Great. So the idea there is to put some patent examiners on the ground who are more knowledgeable in the industries in those areas. So we're going to have folks in Detroit who know about auto tech, and in Dallas who know about aerospace, and in San Jose who know about computers, which strikes me as a step in the right direction. But Jeff, you seem pretty skeptical that this is really going to help much.
Well, I don't know if I'm skeptical. Well, I mean, a little bit. I don't think it's a magic bullet. I think especially in Silicon Valley, the enormous challenge the Patent Office faces is it's going to have to, it says it desperately wants electrical engineers. Well, if you're an electrical engineer living in San Jose and you have Facebook next door and you have Apple next door and you have Google next door, all of whom can pay you 3 times or 4 times or 10 times the money, are you going to go examine patents for a living? That, I think, is a big challenge. But I like the fact the Patent Office is trying to do this. And also, a patent litigator I spoke to in San Jose said that they're hoping to expand a practice in the past where the companies are actually going to go in and train the examiners. So this means Google or Apple can send in their own tech people to work with the patent examiners and bring them up to speed on prior art. This, of course, doesn't address the larger question of whether software patents should exist in the first place, but I think it's an interesting initiative. And it might also create a sort of less Washington-centered bureaucratic patent institution. So I think it's always helpful to have the regulators working directly with the people they're regulating from a sort of a cultural point of view. I think there'll be more understanding that way. But no, I think it's worth a shot. I don't expect much to come of it, though.
All right, Evan, what do you think?
The problem is a lot more than a problem is much bigger than what can be solved by making these satellite offices. Sounds like a good idea to have experts from the companies go in and train examiners. My only concern would be, is that going to somehow bias the examiners in a way that isn't healthy, making decisions that is going to favor patent owners in a way that is not intended by the system. But I think that's a pretty subtle analysis to make, far beyond the scope of what I could do here. But that's the issue that I would spot in all of this.
All right. Well, we've moved too far away from creepy. I think we should go back to it for a while here in the form of a determination from Judge Ciarino Jr. That Jeff has written about in some detail. And the upshot here is that the holder of a Twitter account, whose name, I forget his first name, but his last name is Harris, was asked to, I believe what happened was Twitter was subpoenaed. Mr. Harris was involved in a demonstration, and the police were attempting to do some prosecution for unlawful acts associated with the demonstration and trying to get information from his Twitter account. Well, he first moved to quash the subpoena. The judge said, no. Although this is your Twitter account, Mr. Harris, actually the data in that account belongs to Twitter. So if anybody's going to quash this subpoena, it's going to be Twitter, who of course then moved into motion to quash the subpoena. And the ultimate outcome was that the motion to quash was denied, and Twitter was ordered to turn over the account information to the judge for his review on what was and what was not going to be relevant to the prosecution. The ACLU, of course, is up in arms about this, and I see a lot of reason to be concerned about it as well. Jeff, what's your take?
The outcome of the case wasn't that outlandish. If we take it to say, if you tweet something, can it be used as evidence against you? I don't think that's crazy, because if you blog something or I go on the show and say something, it's inherently a public forum. The problem is, frankly, this judge and his earlier decision and the next decision. First off, the lack of standing to assert ownership rights in your own writing, I think, is a bit troubling. I don't like the reasoning on that at all, because this will apply equally to your Gmail account, to your Facebook profile, and on and on. So if you can't stand up for your own writing and your own sort of written property, and have to rely on the companies to do it, I'm not sure if that's the best way to go about these things, if that makes sense. That was the first decision when he quashed the Occupy Wall Street protester for not having standing. And then the second decision was almost worse. I've never before called a judge a buffoon before, but I did in a tweet this week because he seems to have a fetish with social media, right down to punctuating his judgment with #quash. I think there's the issues are more serious here than befits doing something like that. Am I making sense so far?
Yes, you definitely are. The other thing that you wrote about that made its way into the judge's decision-making process is a Supreme Court decision from several years back that decided that financial institution data, data about what's in your bank account, et cetera, belongs to the financial institution as opposed to you. And he analogized to that in reaching this determination about Twitter. And that seems to me a pretty large leap. What do you think, Evan?
Well, I'm concerned about this expectation of privacy that one has in data in the cloud. And this situation just underscores that. And it's one where the jurisprudence from the 1980s that we're talking about here, the expectation of privacy in records that are held by someone else, is problematic. This is an area where we need some upgrading of our expectations of privacy, both in the Fourth Amendment context and in other privacy contexts for the modern age. So this is another way of saying that the real problem with the judge's decision here was not meaningfully recognizing the differentiation between content that's clearly public, the tweets that you actually put out, things that you say to everyone, and the other content, the other information, the non-content information, like the location data, account information, IP addresses, and all that stuff. That should be subject to a much more restrictive analysis than the stuff that's clearly public. And I think that if there's one clear deficiency in the judge's ruling, it's that it's failing to recognize that distinction And I think it was Jeff's piece that did a great job of bringing out the inconsistency in that. Was that you, Jeff, that talked about how he was talking about the founding fathers who would have loved using Twitter and to sometimes even tweet anonymously? Well, the real, I guess it's irony that the judge's decision doesn't meaningfully take into account that right of anonymity because it doesn't make that distinction here. So there's definitely some problems with it, and it's something that is kind of a necessary tension with so much information, so much useful information being outside of the custody and control of the actual person that, for example, the Fourth Amendment talked about 230 some years ago, or 200 some years ago.
I think, Jeff, you were honing in on maybe there should be a distinction in the courts between someone who's a publisher like Twitter and someone who is a bank. Am I right?
Yeah, there's a couple things going on because that case Miller is from 1978. And remember, we didn't have Twitter accounts in 1978. We didn't have computers in 1978. That case applies to boxes of papers in a bank, which I think clearly is, and the rationale is that's the bank's property, not your property. But on my Facebook or my Twitter account, I've got photos of my family, I've got my thoughts, I've got my location, I have all of that. So to go and transpose that notion of bank property onto that, something is wrong. And I think Evan put his finger on it when he noted that there's a sort of public face of a lot of these things. If I write on Google Plus what I did today, or on Twitter, or a public Facebook page, but there's also a lot of stuff on those platforms that are not public, that are mine. It doesn't mean the police can never have them, but I want to be able to go into court and to stand up for them, not be able to told that I have no standing to speak for them in the first place. That's, I think, where the New York judge has went badly off the rails.
Yeah, that's an excellent point. If you're let's use his bank analogy. If you have an interest in, you certainly have a very strong interest in maintaining the privacy of your financial data. There are all sorts of federal regulations that come into play there. And if your personal financial records are being subpoenaed, I don't think, I'd be very stunned to see a judge come in and say, no, sorry, you don't have any say in that decision whatsoever. That, you even in the face of this Supreme Court decision that he relied on, I'm thinking that still it would be hard to close the courthouse doors on a litigant who could come in and demonstrate that there was no relevance at all to what investigation was proceeding of that information. But I don't know. I mean, I don't practice that particular kind of law, so I could be off base there. But Franklin, what do you think about all this?
I think the judge has the right enthusiasm. It just needs to be tailored in the right direction. I couldn't find any information, Jeff, you might know, about whether Harris, the alleged Occupy protest movement member, had a protected Twitter account during this November, December period of time when that was happening. But Judge Sciarrino Jr. makes note in the first motion to quash that explains some users can choose to protect their tweets when he's explaining what Twitter is in the process of writing out his opinion. And if Harris's account was private, I think this recognition is a strong enough bias to completely go against the judge's holding that Harris's tweets were public. And just adding on to the irony of all of this situation is Sciarrino, if it truly is his real Twitter account, he has a private Twitter account. And in a footnote of one of his opinions, I can't remember which one, if it was the first quash of the individual or the Twitter's attempt, but he added a footnote to Twitter's help section explaining the added tools put in place for a protected user's account. And so for him to be completely going against these protections that Twitter implements for its users, which he is taking full advantage of, I just think there's something wrong in that aspect of his holding.
I'm guessing it was a public account, but I don't know. Do you know that off the top of your head, Jeff?
It wasn't disclosed, but I find, just taking up Franklin's point on the judge's own relation with social media, he's shown a a sort of very poor lack of judgment in the past. The only reason he heard the case is because he got transferred out of another borough as punishment because he kept trying to Facebook friend. He kept trying to make friends with lawyers on Facebook. And even the lawyers in New York City sort of reported him saying this isn't appropriate. So now the same judge who has been disciplined for misusing social media is ruling on perhaps the most important social media case of this year.
Yeah, that is a bit chilling and creepy even. I don't know that the private nature of the account, if, let's assume for the sake of the argument it was a authorized access only, you get to pick and choose who's following you kind of account. I don't know that really would make a huge difference here because, obviously it would be very clear under those circumstances that the tweets were not public. But all the rest of the background information that Twitter has on you, where you are, and your private messages, your DM sort of messages, that those would all be protected, I would hope, in any event, however you decide to treat your tweets. Let us move on to, what we forgot to mention is we were talking about all the patent stuff about Apple. They had this great week in court where they were getting injunctions, but they didn't have such a great week on social media channels. And this is the first time I've ever seen, it takes a lot to get a trending topic on Google Plus or on Twitter, a pretty big event, like maybe Katie Holmes and Tom Cruise, something earth-shattering to get yourself a trending topic. But the hashtag boycott Apple was trending on both systems earlier this week. At least I'm told it was trending on Twitter. I didn't actually see it there, but I did see it on Google+. So that's the first time I've ever seen protest over overarching patent problems and the broken patent system that prompted the commentary we were talking about from Judge Posner actually filter out and have that kind of a public reaction. Other than SOPA. Mm-hmm. So I'm wondering if you guys saw that, if you were, impressed by the fact that people came out. Now, when I posted that I thought it was interesting, Chris Brogan came along on Google Plus and said, yeah, it's interesting that it's the network that's highly populated by Google employees, and he thinks that there may be some sort of partisan bent to what happens on Google Plus. I don't know. It's got millions and millions of users who don't work for Google. So, Jeff, were you impressed by this?
I saw some of the boycott Apple tags showing up on my reader comments on stories I wrote, and I was a bit surprised because Apple is not only a wizard of design and gadgets, they're also very good in court, but also they're even better at PR. So you very rarely see negative PR directed at Apple. Is Google stirring the pot? Probably. But just in the same way, other companies stir the pot against Google with funding journalists to write propaganda and things like that. But yeah, I think you make a good point. It's rare to see Apple on its heels on social media.
Yeah. Evan, do you think that this is folks actually starting to reconsider their purchase of Apple products, or is this just a small cadre of patent reform activists?
Well, it could be a little bit of both of those. Apple certainly is a polarizing influence in all of this. So it's no surprise, no mistake, no mystery that it would be Apple that is the substance, or maybe it's just the catalyst for this kind of discussion to rise to prominence in the way that it did by becoming a trending topic on those social networks. My concern is that we shouldn't be quick to blame Apple in all of this, because they're doing what a reasonable business should do in leveraging and exploiting and protecting its intellectual property. Wait, I just realized I said something incredibly controversial, so maybe I should take a deep breath. what I'm wanting to work in here is, and by doing that, I step on like a landmine or something. Did not intend to do that. What I'm trying to work in here is a quote from that piece on Judge Posner, where he was saying that companies will do what companies do, and he used a biological evolution metaphor to say that companies are like predators. They will use whatever teeth and claws and other parts that they can, which is permitted by the ecosystem, to get ahead in terms of survival and adaptation and all that stuff. I'm adding some words to his metaphor there, but my concern is that we shouldn't be too quick to be critical of Apple for doing this, in as much as it's doing what at least the patent system will permit it to do, regardless of the state of brokenness or lack of brokenness of that patent system.
Indeed. Franklin, we're going to make boycott Apple our second MCLE passphrase for the show. You got kind of into it with a few people in a comment on my site when I posted about this, or my Google Plus page. And I think your point was basically the same as Evan's and Judge Posner's, that it's not Apple's fault here. They're leveraging the tools that the law gives them. Do I have you right?
That's right. I do agree. I'm still moldable, I guess you could say, in terms of this whole these patent disputes that are going on. And so I'm still forming my own opinions and ideas about how the patent system and the copyright system and the trademark system are working now. And I definitely look to people like Judge Posner and maybe even the other judge we were talking about, Sciarrino. I look to the judges to and that's kind of what law school teaches you, is you look to the judges and the people that are writing these opinions, and you look to them for guidance and how the views that they express and they hold, and you kind of critique that or you accept it. And I'm kind of still playing around with all this idea of what the patent system should look like and how it will look like over the years as people keep boycotting Apple, for instance, and we might see reform. So it'll be interesting to see how it grows.
Well, another way that people are speaking out or may speak out against things that they don't like happening in the world of technology law and here on the topic of internet censorship is there may be a new status code, like a 404 not found message when you hit a website that is down. The Internet Engineering Task Force is considering using status code 451 to indicate that a site has been brought down because an ISP, for example, has blocked access to the site, or the government has ordered an ISP to block access to a site. So I just throw that out as a little nugget. Kind of interesting that we might see error code 451 coming. Evan, any thoughts about that?
It's clever. I also have seen some folks talk about how the error code should be 512 for content that has been removed pursuant to a DMCA takedown notice. So interesting to see cultural references worked into the fabric of the internet. So yeah, clever, interesting, cool.
Yes. Jeff, anything on this?
Yeah, I think that's clever. You put your finger on that. That was a kind of neat little meme that emerged this month. But it also coincides with Twitter deciding to issue a transparency report like Google does, showing just how many accounts and pages are being taken down. So, while it's distressing, it always is, blah, 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 it's also good to see the level of transparency going up. And there's more fingerprints of when something's gone wrong out there than before.
Right. So, Jeff, you wrote about something I thought was pretty funny, well, kind of sad, funny. Apple has had its ups and downs lately in the legal system, and this would be on the downside over in China. I think we've talked about these cases before. There was an entity in China that sued Apple for trademark violation in using the term iPad, and Apple has paid them off handsomely. And hard on the heels of that, they're getting slapped with, a similar kind of shakedown or stick up, as you put it in your article. Where do you think all this stands?
I think, after they settled the iPad thing, someone came out demanding money for snow leopard, and I think there was actually another one this morning or yesterday. China and intellectual property, I don't like to say this bluntly, but I mean, they don't really mix. China doesn't care about intellectual property. And that's not unreasonable, because developing countries that haven't fully industrialized need to look for advantages to catch up. That's what America did when it opened shop. Alexander Hamilton's industrial policy was to disregard the intellectual property laws of Great Britain in order for America to develop its own technology and industrial base. But when you hear China sort of being sanctimonious about trademark or intellectual property rights, you can be pretty sure something else is going on.
Absolutely. Evan, do you think that it's wise for Apple to keep paying off these folks in China who come after them, claiming, lo and behold, turnabout is fair play, intellectual property violations?
It's a fine line they've got to walk, just like it's a fine line that any defendant has to walk when it is deciding whether to settle for nuisance value. This phenomenon is nothing unique to dealing with Chinese intellectual property plaintiffs, I guess, or, whatever, claimants. The same thing goes here when you're dealing with patent trolls in the U.S. If you get a letter from LoadSys, do you settle quickly so that you put a bunch of blood in the water and other sharks can come and attack, or do you protract it, wait for the right time to settle? So it's nothing that's special with China. It's just a problem that that presents itself anytime that a intellectual property holder is going to be unscrupulous in the types of claims and the parties against whom that intellectual property holder is going to pursue.
So, Franklin, maybe this is Apple's justification for pursuing patent litigation in a way that is unpopular. It's bleeding money out the back end in China for other intellectual property issues.
Yeah, I kind of am having a hard time understanding why I think Jeff's article mentions it's a chemical company that has the trademark. I don't see I don't know how any Chinese citizens would confuse buying chemicals to install on their computer rather than the operating system from an Apple store. I just don't see where the confusion would fall in line there. So that's something I don't really understand as to why this is even going to court.
Yep, it is a little bit mystifying. Well, we were talking about Twitter and access to Twitter accounts. Of course, anonymity and pseudonyms and parodies are pretty popular on Twitter. And some of them are stealthy enough or not overt enough in their presentation of being a fake account that they can take in some pretty reputable folks, some folks who do real journalism. I think you pointed to this on Pointer, Jeff, that the fake New York Times ombudsman took some people in tweeting about Anderson Cooper, made a joke, made a little dig at CNN about its whole snafu in misreporting the Supreme Court health care decision. And the fake New York Times public editor tweeted that CNN is reporting that Anderson Cooper is straight, an inaccurate thing. So I just think it's pretty funny that that these fake accounts, which are controversial legally, it sort of exist in a legal gray area. Google came out with Google Plus and decided they wanted people to try and be who they were and took all kinds of flack for that. Twitter has always let people have parody accounts. Of course, there's a fine line when you're masquerading as someone else, and that's illegal in many places, and Twitter doesn't allow that. But they'll allow you to exercise your free speech rights. But the buyer must beware when taking in that kind of information. Any further thoughts on that, Jeff?
Just that the fake Twitter accounts are great fun. There's one called Fake Jeff Jarvis, who's sort of a very sort of pretentious journalist, and I mean he's a sort of known journalist intellectual. But fake Jeff Jarvis is actually a lot better and more informative. And actually, the real Jeff Jarvis tweets the fake Jeff Jarvis. So I just got to say, great on Twitter for allowing these things to go the way they do.
And great on Jeff for having a symbiotic relationship with his fake account. Evan, what do you think?
I guess, again, a first world problem. What it does is underscores the problems with the ephemeral nature of this stuff and the fast pace at which the information is sent out and consumed, because you can easily overlook in the description that this is a fake account, which is what's going on with the story with the fake ombudsman. Don't you love that word, ombudsman?
I do.
Going on in this situation here. So I guess it also illuminates one of those ideas of what is allowable as a parody or a satire, depending on what it's trying to be in the fair use analysis with copyright law, because it's got to be fake enough that you can see that it's really fake. It can't be too good of an imitation, or else the use is not transformative. So we can use it to work into some thinking and talking about what it means for it to be transformative in terms of fair use. But clearly in this situation, it's all in good fun, and certainly nothing shouldn't be anything seen as unlawful in what's going on here. This all has to do with norms and ethics and what's good etiquette on using Twitter and other social media.
Yes, Jeff Sonderman, who wrote about this at Poynter, had some fun with it too and said, you really should just make a better joke if you're going to be tweeting this sort of thing. And he quotes one: CNN reports Anderson Cooper striking down individual mandates.
That is
originally
funny.
From, at producer Matthew, whoever that is. So Franklin, you've never had the problem of when folks have come and all the chicanery around law school, you've never had someone posting fake tweets for you?
Definitely no. I have not given anybody else access or permission to create a fake Twitter account, although I don't think I qualify as a celebrity or a public figure in any sense of the term. I do think it's funny, as Patterson pointed out in the IRC, when you see things like The Onion, you clearly know that they're fake, or you hope most people do. I know one time my friends thought Bill Nye had actually died, and thanks to The Onion, it was fake. But I think that the difference, as Evan was saying, comes in when this Twitter account, I had trouble telling the difference between the two, because as the article stated, they use the exact same promotional picture, which I don't know how that would play in as well, because they probably don't have the rights to that, but it could qualify as a parody, I guess. But having one line that says this might be a fake account, that to me, I was having trouble differentiating between the two, just looking at them when they were putting them side by side on purpose. So
yeah,
it's pretty funny overall.
Yeah, I was interested in getting your take. Go ahead, Evan. I was going to move off this topic, so if you have something on it, drop it in.
Just real quick, back in February, we may have talked about this on the show. There was a Republican congressman from Louisiana named John Fleming. I'm reading an article about him here. He saw an article in The Onion about an $8 billion abortion plex opening in Topeka, Kansas, and put up a tweet about it, or maybe he updated his Facebook status and said more on Planned Parenthood, abortion by the wholesale, and linked to this Onion article. The clear import of this was that the congressman thought the Onion article was
real. Yeah. It's, I guess, like Judge Cirino and Twitter. Use social media at your own risk. And to that point, Franklin, I wanted to get your take on what Lauren Gelman was saying last week about law students and social media. I mean, you have a Twitter account and a blog, and you're here being pretty public with us on the show today and working behind the scenes for us on other days. Do you think that that's the exception and not the rule as far as your fellow students?
As we hopefully find time in between reading and studying and preparing for class, obviously we like to have extra time for the social networks. But I can't speak for any other fellow classmates of mine, but I choose to put myself out there so that the information that's out there is what I want it to be, to a certain extent, obviously. And so that's why I went ahead and made myself a Twitter account, made myself a YouTube, and I grabbed up all of the social media platforms that I thought were reasonable, because you never know at a certain time when they will become helpful. But being in the technology field as well, and coming from a journalism background as well, in undergrad, I think that it was ingrained in me that being out there is not a bad thing if you can control it. And I think that's one of the biggest things that I'm learning out of it, is being controlled with what I'm putting out there and practicing the responsibility. And hopefully Facebook won't go and mess up their privacy settings again and share things that I've only shared with certain people. But you just have to hope that that won't happen, and be diligent in what you're posting to Facebook, even if it's private. I just have the expectation that whatever I put on those sites is not going to be private. And years from now, if I'm in a position where somebody could use what I've said against me, I will say that was me then, and I said that, or I'm not embarrassed by it, because right now there's nothing I'm embarrassed by. So hopefully it won't come back to haunt me.
Right. And as we've seen today, even if you are, using Facebook or someone else's settings to keep things private, there's nothing to say a judge might not come along and say, well, if it's been subpoenaed by law enforcement, fork it on over. Let's go to our tip of the week, which we touched on last week, the big SWAT team raid on the open Wi-Fi. We're going to come back to that and actually make it a tip. And I guess it could be two things. Either secure your home Wi-Fi or follow the lead of, there's a great Ars Technica piece on this whole thing. And mentioned in there is how the FBI takes a different approach to this sort of thing than the local SWAT team who went in and found, open door, 18-year-old watching TV at home. They were looking for someone who'd threatened the police, went in with the SWAT team and of course didn't find them, but someone had borrowed this open Wi-Fi connection. What the FBI actually does is sort of war drives around and sees what kind of Wi-Fi connection it is detecting. And if it's encrypted, they make certain assumptions about, okay, then if we think that that's where the person was, then there's a better chance of it actually being that residence and not someone coming along and jumping on their Wi-Fi. So either secure it, or we've got to make sure that law enforcement follows the lead of the FBI and knows a little bit more about how Wi-Fi operates. Evan, I thought we were moving toward this, wonderful world where we all share our Wi-Fi with our neighbors in sort of cup of sugar fashion. You just don't think that's a good idea?
Well, I mean, as in the abstract, it sounds good because, you would think that whatever, we could get all airy about this stuff. Everybody would benefit if we know that you're going to have high-speed access to the internet wherever it is. But it doesn't take too much effort to come up, one, with some thought experiments to see how things could go wrong. I actually wrote an article for the Journal of Internet Law back in 2006 about this, kind of just thinking about all the risk of liability there is to an open hotspot owner, all the way from copyright infringement liability to much more sinister things like the distribution of child pornography. So with stories like this, with the police from Evansville, Indiana, with the SWAT team coming in based on the erroneous assumption that the IP address owner associated with the open Wi-Fi hotspot connection was the perpetrator, that really brings to light the fact that there's a risk not just for civil liability, not just for criminal liability, but for truly being in the wrong place at the wrong time, being perfectly innocent, and having it really kind of being a pretty rotten day if the SWAT team comes and raise your house, especially if you're sitting there doing bong hits. I don't know, and you had nothing to do with the internet crime, but you can see where this was going.
Judicious use of SWAT teams is always a good idea.
I think so.
Evan, our resources of the week are twofold. You noted that Franklin was using Facebook in college. In law school, he's using Evernote. How about that? Wouldn't it have been great to have Evernote as a tool for taking notes and sharing them in law school? I really liked your piece on this, Franklin. I hope you continue informing folks of what's making life easier for you in law school. It sounds like you're using it mostly on your iPad to do this.
I actually did an experiment. The first semester, I used my laptop, and I honestly never even used Evernote. I heard a little bits about it, but it was installed on my computer. One of those wonderful installed programs that come on a Sony computer. And I started using that, and then I got an iPad around Christmas, and then I started using the iPad, and I figured why not switch over to the iPad and create a story out of it. And I also started using other apps, which I'll write about later on, like the Westlaw Next app and other wonderful law school or law practicing apps as well. And although I won't be able to comment on the law practice side of them, I will give the law student perspective on them as well coming up.
Yes. So law school has become this place where folks forward each other PDFs via Evernote to share notes. We used to actually have to go to a bar and drink some to do that. So I don't know if this is necessarily a good development. Our other resource of the week, I encourage people to check out, both because it sounds like a good story, and it's by one of our friends of the show, Tim Street, who's been on before. And it's a great opportunity to check out how these very interactive multimedia iBooks using iBook Author can be made and what they're like. And it's on a topic that is right in line with everything we've been talking about today, your privacy and who has access to what information about you. Tim Street has written an iBook. It's only available as an iBook because of all the added video and imagery in it. It's called Vids. And it's basically what was that movie with... it was out when I was in college, Fatal Attraction. It's as if Fatal Attraction and Glenn Close had access to all of the social media data and information and all the surveillance tools that are available today. And what she does, basically, a woman who's having an affair with a male married lobbyist in Washington is jilted by him and then decides to make his life miserable by collating data about all his other affairs and putting them publicly online for his wife and all his Washington colleagues to appreciate, and then she disappears. So it's a mystery as to what happened to her and whether the lobbyist himself did it and stuff. It looks really fun. It's only $3.99 on iBooks, and of course you can download a free sample if you have the iBooks app. So good luck, Tim, with that. He's been working on that project for 10 years, he says, and it looks like a lot of hard work and love and care and good storytelling went into it. So kudos to you, Tim, for getting that done by your target deadline, Independence Day, 4th of July this year. And with that, we'll go ahead and wrap up the show. I've really enjoyed our conversation and all your great insights, Jeff. Thanks so much for joining us.
Thanks so much for having me.
Now, you write for both paid content and GigaOM. They are basically two sides of the same coin?
It's becoming that, yeah. It's sort of exciting. GigaOM is the leading West Coast technology blog, and paid content's traditional writing about the New York media scene. So we've come together, and so now our media coverage is more technology infused. And it's a great opportunity. So please check out our site.
I love it. I'm more and more relying it ever since Huffington Post and AOL acquired TechCrunch. I'm more and more relying on your writing and those of your colleagues at both paid content and GigaOM to keep me informed on all of the important issues related to technology and the law. So we really appreciate your great work and are so glad you could join us today.
Thanks. It's been fun.
Good. Evan, great to see you as always.
Yes,
anything fun going on with you?
Everything's all good here. I'm just taking a little break this week for 4th of July, so I'll be back in the office on Monday, and nose to the grindstone as always.
As always, yes. Franklin, back nose to the grindstone for you. Thank you so much for all that you've been doing to help us out this summer on your break from school. It's really been invaluable, and we've loved having the chance to talk with you today and introduce you to the audience.
I really enjoyed it as well. It's been an awesome experience so far, and looking forward to the next month or so as well, continuing on.
Great. All right, guys, let's wrap it on up. Everyone enjoy their post-holiday weekend, and we will see you next week at 11 o'clock Pacific, 1800 UTC. That's when we record the show live. So if you join us at TWiT.tv, then you can watch along with us while we record. If that's not working in your schedule, don't worry. You can find us at TWiT.tv/TWiL. The whole archive of our shows is there. You can find us on YouTube. You can find us in iTunes, however you like to consume your web video and audio programming. We're going to be there for you. What else should I tell you? We have a Facebook page. That's at facebook.com/thisweekinlaw. We have a Google Plus page, and I'm always posting things there and on my personal Google Plus page about the topics that we're developing for the show. We have a Delicious account where you can see all those topics aggregated. That's delicious.com/thisweekinlaw. And then the episode number /169 is going to get you to all the points that we have just finished chewing over. You can tag things on Delicious for This Week in Law, and that way I'll see them and consider putting them in our rundown. I'm also considering, we've used Delicious from the get-go. Reddit is seeming to be very helpful for TNT. I'm wondering, if anyone has any pros and cons, wants to lobby me to change how we do things, let me know. You can email me at denise@twit.tv, or you can drop Evan a line. He's evan@twit.tv. We love to hear from you with all of your thoughts for the show, whether they're suggestions, questions, comments, random things that just pop into your head. We love hearing from you, and we're so glad that you've chosen to join us today. We know your time is valuable, and we hope that we have given you something of value for listening to the show. So we hope you'll continue to do so, and we'll see you next week on This Week in Law.